So what happened was that 42 vacancies were advertised. 2,751 people took the preliminary exam. 421 were found fit to take the main exam. Only 43 were called for Viva and only 13 were selected. Now the three petitioners before your lordship, my lord, they secured fairly good marks in the written parts. There were two papers, both of 100 marks, and there was a interview of 50 marks. They have been... Yes.
Country,
Yes.
this rule is mandatory in all states that you have to not only qualify the minimum marks in the written exam, there is a minimum prescription for Viva Voce also.
This is one problem because, my lord, this issue has been examined by this court in several cases. Unfortunately, there are some contradictory judgments of this court whether minimum marks can be prescribed for the interview. There are two issues. One is whether more than a certain percentage of the total marks can be prescribed for the interview. And the second is whether minimum cutoff marks for the interview itself can be prescribed. On both those issues, my lord, there are several judgments of this court which say that the maximum marks for the interview should not be more than 12% or something like that, as compared to the total number of marks. And there are some judgments which also say that there should not be a minimum cutoff.
No, that you are referring to Ashok Yadav and subsequent one.
Yes, that's right.
That's a different issue. Suppose 12% are prescribed.
Yeah.
For the
minimum cutoff, your lordship. Now the question is, my lord, what is happening is this minimum cutoff, just as, my lord, prescribing too many marks for the interview has been found to be arbitrary in Ashok Yadav, etc., that the large percentage cannot be prescribed for the interview. If you prescribe a minimum cutoff marks, my lord, it gives a kind of arbitrary power to those who are in the interview panel to fail people just on account of the interview.
Normally in every high court,
yes,
Chief Justice himself and the senior most judges will sit for interview. Now in judicial services, how the candidate react to a question, how he behaves, the body language, the temperament, all these factors are very, very important.
No, there could be, but it could also be possible, my lord, that some judge who's in the interview panel, he kind of takes a dislike to a particular candidate for some reason. And dislike can always be very subjective. He has worn a particular dress or he speaks in a particular manner, etc. And therefore, my lord, gives him very low marks in the interview, effectively fails him in the interview. That is why, my lord, when this issue has been agitated, and my lord, this has been happening now consistently in many judicial service examinations. I am finding, I have dealt with so many cases of judicial service examinations. Vacancies advertised are X. The number of people finally selected are 1/4 or 1/5 of X. And the major reason for people not being selected is that they have failed the cutoff. Sometimes, Lord, they fail the cutoff of the written exams, but very often they fail the cutoff of the interview. In this case, my lord, these petitioners secured high marks in the written exams, and in fact, one of them secured the third highest marks in the written exam, and she has been given 18 out of 40 in the interview. 18 out of 50, sorry. The minimum cutoff was 20. So that is why, my lord,
I think that any selection committee will have any idea about the written examination. Be the consistent practice that nobody will come to know that what is the position, merit position in the written exam. At least in 2009 to 18, I have been regularly associated.
yes.
There is no question of knowing it.
No question of knowing?
Marks in the written
marks. But now, of course, my lord, people are given marks even under RTI. They are disclosed the marks.
No, Mr. Bhushan, you not got us right. What we are saying is when the interview panel interviews the candidate, the panelists are not aware of the marks which is awarded.
No, sir. They may not be aware. I'm not saying.
That is very relevant. when there is a question of
Yes,
a
yes, I
bias and
agree.
thereby fixing a particular number so that the candidate.
No, I agree.
fails.
I agree. But they are aware of the fact
There is
that
nothing
this
like-
interview has a minimum cutoff. Now, if my lord, for some reason, I'm not saying that.
Of course, a member of the selection committee will know
Yes.
that suppose out of 100, suppose 100 marks are for Viva.
Yes,
He or she will know that unless this candidate is awarded 40 marks,
yes.
the
He will-
candidate can be disqualified.
Yes. He will stand disqualified.
This much he will know because
Yes, of course.
the minimum marks are prescribed.
Yes.
But he will not come to know that in the written
I
exam.
agree. He may not come to know that.
Subsequently,
But here you have not challenged the rule. You have not challenged the rule in this case.
Lord, effectively, that's what it comes to.
have
What
not
I have said is that it is arbitrary. What we have said is, it is arbitrary to fail us on the basis of just the interview marks, not receiving the cutoff of the interview marks. Actually, my lord, this is a larger issue which I feel, my lord, this court needs to revisit in a larger. Unfortunately, there are several benches decisions. Some say that minimum cutoff cannot be prescribed. Others say minimum cutoff can be prescribed. There are also judgments which say, as regarding that Kothari Commission, etc., that the maximum marks for the interview should be 12.5%. Ashok Yadav, etc. Here, of course, the marks for the interview are 20%. And in that 20% marks for the interview, the minimum qualification marks is 40%.
Yadav also, you will see, Mr. Bhushan, that for the higher posts, which are based upon experience,
Yeah.
even there also recommendation is that we higher marks for Viva also. But for say, for example, if you are recruiting newly graduates, law graduates,
For the lower judicial. Lower
for the entry level,
Yes.
then marks should be minimum, that 12% or something,
Mhm.
but written examination will be more. But if you go for a district judge,
Yes.
then you are examining a person, you are interviewing a person who had 10-year, 12-year, 7-year minimum practice to his credit.
Now, the question is, my lord, whether there should be a minimum cutoff for the interview or not. This is the question.
Mr. Bhushan, how can you permit a candidate who knew very well when it appeared in the exam, he took a chance?
I'm dehorsed that. I'm on a larger issue. I think, my lord, the time has come for this court to revisit this issue as to, I agree that interview can be there, interview should be there. But the question is, what should be the maximum marks, percentage of marks for the interview for each exam? And number two, my lord, whether there can be a minimum cutoff for the interview? Because some courts are.
For that, Mr. Bhushan, it's not that we are always open to examine that. For that, the judicial services matter is pending before a 3-judge bench.
Yes.
Right now with me, Justice Manoj Chandra and Justice Anasi is there. Because earlier, the judgment in Superior Judicial Service, the recent judgments are by that bench. So there may be that someone can apply and you can also assist on that after collating a comparative information, a chart from different.
So I am happy to do that because I have appeared in several such cases of several higher judicial service in several states.
At least one thing should be, one can be easily argued, and that though it is the state prerogative, that states have their own service rules, that power is there with the states, but that the uniform pattern can be introduced. Minimum with a uniform pattern.
Actually, in several cases, at least in 3 cases, Your Lordship, this court has said that the mere fact that only 1/4 of the vacancies have been filled up by this exam shows. The first case was that Center for Public Interest Litigation regarding the Delhi lower judiciary, where, my lord, 8,000 people had appeared for the judicial services, 80 vacancies were there, and only 12 people were selected. So the court felt, that was Justice Deepak Mishra's judgment, the court felt that, look, there appears to be some problem with this evaluation. Therefore, my lord, they appointed a re-examining committee under Justice Sikri, etc. And thereafter, my lord, many more people, another 15 people, got selected. So that's why this court has in several cases been examining this issue as to whether such an evaluation, my lord, is appropriate or not, and therefore it has asked other committees to examine it. I feel, my lord, that in this case also your lordship can ask for that examination. Of course, here there are only 3 petitioners before your lordship.
See, also that, see the other consequences means the candidate must have told you who are the judges in the interview committee. And particularly in High Court like Maharashtra.
Chief was not there, I am told. Chief Justice was not there in the interview.
Maybe. In some of these High Courts.
And, my lord, despite the fact that 7-8 minutes per person. Total. Yeah, I am told that for 43 candidates who were called for the interviews were over in a total of 8 minutes or so. So it was a very hurried, cursory interview, and this court has said in that Ashok Yadav that the interview should last for about 25 to 30 minutes if you want to prescribe reasonably high marks for the interview, etc. So actually, my lord, this problem is recurringly coming before various courts.
How they will.
And my lord, if your lordship keeps saying that there is a rule which prescribes minimum marks and only so many people have got minimum marks and therefore no other people got selected, my lord, we are seeing that these vacancies are piling on, continuing to skyrocket, and vacancies are not being filled up. There is a problem. There is a serious problem. And that is why I want your lordship to examine this issue.
Some of the High Court, the problem in the interview, there were instances where, as we came to know on administrative side, that some candidates, say for example, you appear in XYZ state and you belong to North India, you go to South, the South candidate qualify for, there in the interviews, judges felt and maybe realized that because of the language barrier, he will not be able to interact properly with the witnesses, with the local people, or with even the district bar members. So therefore, they discourage them by awarding some. But that is also not the case here. I just wanted to see that all 3 are from Maharashtra. 2 of them are from Mumbai. One is from Chhatrapati Sambhajinagar again.
They are. One of them is a lady. The applicant number 2 is a lady who got the 3rd highest marks in the written paper, and with her present interview marks, she would have been selected. She would have been, her marks would have been above. If there was no cutoff for interview, she would have been selected. Her marks are above the marks of the lowest selected candidate, whose marks were 140 from the general category. Her marks would have been 142, even if she was given only 18, as she has been given.
Relaxation of
is that 3 times the number of vacancies should be called for the interview. Here, my lord, only 43 candidates for 42 vacancies.
So sometimes the requisite candidate don't qualify the written.
In the written exam. So
that must be the real reason. We know that must be the only reason.
maybe.
And Mr. Bhushan,
Yes.
for your information, the seats don't remain vacant because all the high courts have a rule that if the candidates from direct recruit or the limited competitive examination do not fill the requisite, it will be filled up through ordinary process.
Maybe that is true in the higher judicial service, maybe.
Higher judicial.
But certainly not true in the lower judiciary. Lower judiciary, we are seeing, Lord, I am seeing consistently, state after state, that certain number of vacancies are advertised, 1/3, 1/4 are selected.
But Mr. Bhushan, that's a very big problem
Yes.
of employability. There are number of law graduates. Many people take exam. But when
Actually-
it comes to recruitment, we have to also have a basic minimum standard.
I agree.
So that
I agree. There are lots of
becoming a
quacks in
judge
this
does
profession,
not
no doubt about it.
fall into
I do not doubt for a moment, my lord.
Coupled with it, what my brother has pointed out, now on judicial side, we have now mandated that examination will be every year. So, every year, from where are you going to get the talent? It's not that a candidate today, suppose he is 35 years, 36 years, he is qualified. Understandable that after 1 year, 2 years, 3 years, he is working hard, and after 2, 3 years, he gives good performance. Problem is the annual exam, though we keep on, sometimes we also don't realize that directions are salutary because the posts were lying on field for years. But I think after reaching to a kind of up to a saturation point, this is also a mind-boggling exercise. That are we able to have enough market available of the meritorious candidates?
Actually, in the Delhi recruitment for the lower judiciary, so the situation was this, that many people who were already selected for the lower judiciary in other states were disqualified in the Delhi Judicial Service exam. Some of them had topped the judicial service exams while being selected in other states. Some of them were toppers of national law schools who had been outstanding students. They had also been disqualified or failed, etc. And that is why, my lord, the court asked that, all right, let us have the papers re-examined by, and this has happened 3 times, not once. In 3 cases, this court has done that. In every case, my lord, many more people have been selected thereafter.
In the written examination, Mr. Bhushan, possibility of once a lifetime error cannot be ruled out for 2 reasons.
Yes.
One is that either the evaluation takes place through some software in some of the cases, or the examiners are also not under the administrative asset.
Papers are very tough.
Very tough.
And, my lord, I am recently dealing with a case of Punjab and Haryana, from where your lordship is familiar, which is pending before the High Court, where, my lord, the answer sheets have been given. And one can see from the answer sheets that persons who have given absolutely the correct answer to the question, I have seen, have been given the same marks, half marks, as the person who has given absolutely the wrong answer. So, and this has happened not in one question, but in several questions. And one of the problems that we have also seen is that the examination papers for the higher judicial service are often being given for checking to the members of the higher judicial service of the same state. What happens is that those people who are members of the higher judicial service of the same state, my lord, they have some kind of an interest sometimes in seeing that not many direct recruits get selected and that people from the lower judiciary are promoted. So therefore,
that this kind of practice can be discouraged where the judicial officers are asked to evaluate the answer sheets for 2 reasons. One is that evaluation of answer sheet is a typical temperament. It's a different, a more an academic exercise. 1, 2, the judicial officers are so preoccupied with their day-to-day work, it's become difficult for them to apply.
It should actually be given to some retired people.
Either retired,
yes,
or you should engage always academia. And now in Chandigarh, I do not know what's happening right now, what is the prevailing practice. We used to engage the services of a serving vice chancellor of a law university, requesting him to pick up his team from different law schools, not from his own law school. And that entire team will come, stay in the judicial academy. On the round table, they will sit. And question number 5 will be evaluated by 1 person for all. Question number 6 will be evaluated by 1 person for all. And this is how the answer sheet will keep on rolling like this.
that would be much better, for sure. But what I'm saying is, my lord,
This I
this
introduced with
this-
John Eyebrow.
this thing of my lord, minimum cutoff in the interview, when an interview is so cursory, as I am being told, that the interview hardly lasted less than 1 minute per person. So therefore, this, my lord, will make this whole selection process very arbitrary. That's why I'm saying, my lord, that your lordship should examine this question, re-examine this question as to whether minimum cutoff should be there.
Mr. Bhushan, now to entertain on this ground will be very difficult that 1 minute was given or not. We can at the best, because the vacancies are there, we can request the High Court to sympathetically reconsider for the relaxation of rule, or maybe because there are only 3 candidates, to recall them, and if the High Court so decides.
Let them be re-examined in an interview by the any panel headed by the Chief Justice or something like that. In this case, I am told the
Not
Chief
say
Justice.
anything which may cause aspersion on the.
Acha, all right. I agree that your lordship should not say anything which will cast any aspersion on the members.
Because in Maharashtra, the unique situation is that the administrative judge of Nagpur will not know the candidates of Bombay. Bombay senior judge will not know about the candidate in Sri Sambhajinagar. So that complete neutrality, impartiality, that even perceived local bias, no question arises there. There are small high court, it can happen. In a small high court where you know the entire bar or so, one understands that this can happen. But not in a place like Bombay, because the 3 places and Nagpur.
Lord, these facts are really a little stark that only 43 people called for the interview, only 13 people selected.
That is the only factor, that because when you undertake an entire exercise of exam, one should also think of what is the output I got.
Yeah.
You spend public money, you spend your, most important, you invest a lot of time. And if ultimately outcome is very minimal, then maybe that sometimes this what.
I understand, my lord. I know that there are a lot of lawyers who are not competent to certainly be appointed to the higher judiciary. That is true. That is a fact. But it is also not true that you cannot even find 42 people in the entire Maharashtra to be appointed in the higher judicial service. That is also not correct, my lord. That you can only find 13 people when so many people, more than 2,500 people have taken the exam.
There are 3 petitions before us. The 3 petitioners in this special petition are practicing advocates in Mumbai and Chhatrapati Sambhajinagar. They appeared in the selection process class 2024 for recruitment to the post of district judges, namely the Maharashtra Higher Judicial Services. The selection process was comprising 2 parts, namely the written examination and Viva question. The petitioners have apparently performed very well in the written examination, and one of them is stated to have secured 3rd position in the SAT examination. There were in all 43 vacancies. Initially 28 vacancy posts were advertised, but subsequently more vacancies became available, which were added through 2 addendums, and consequently it was decided to fill up 42 vacant posts. The petitioners were called for Viva also. However, as they failed to secure minimum 20% marks prescribed in the for the Viva also, prescribed as the qualifying marks.
Less than 40%. They received 40% was the cutoff for the interview. They received less than 40%.
Less than 40. They secured less than 40%.
That is 20 marks.
That is 20 marks in the Viva also, as a result of which their names do not figure in the final selection list. The High Court was able to select only 13 candidates against 42 vacancies. The approach to High Court, however, the petition has been dismissed from giving rise to these proceedings. Then, so we have heard some question on counsel for the petitioner and going to the court. Though various issues of like prescription of minimum marks for Viva voce and or a uniformity in prescription of such marks on pan-India basis have been raised during the course of arguments. However, we are of the view that such issues can be independently examined by this court in the proceedings which are pending before us with respect to the judicial services. As regard to the petitioners, it is evident that they could not be selected only because of their failure to qualify the minimum marks in Viva voce. Since large-scale vacancies have remained unfilled, it seems to us that large-scale vacancies have remained unfilled and 2 out of 3 petitioners are women candidates. 2 are women, I think.
2 are women, yes.
Women candidates. It seems to us that
One of them was the assistant public prosecutor, and she is SC, scheduled caste.
it seems to us that, and one of them being a scheduled caste also, it seems to us that the petitioners claim that the petitioner's candidature can be sympathetically reconsidered by the High Court. So in this regard, if the High Court is satisfied, the requirement of minimum marks in the Viva voce can be relaxed by invoking appropriate powers under the statutory rules and or any other transparent mechanism can be invoked by the High Court for such reconsideration. We, however, leave it to the entire discussion of the High Court to adjust the overall suitability of the petitioner. All that we have observed is that keeping in view the fact that substantial part of the vacancies remained unfilled, the claim of the petitioner may be sympathetically reconsidered. The special petition is disposed of court. Let us see.
I'm deeply obliged, my lord. Very sympathetic consideration.